All right. So, Mapalo, one of the common myths in South African law is that when you live together and you have been in a relationship for a very long period of time, that you are considered married. But in our law, there is no such thing as a common law marriage. And what that does essentially is exposes couples to so-called butt and sit or cohabitation relationships to potential risks if they are not informed. So if you are not married, you will, for example, not enjoy the benefits or protections such as inheritance, such as claiming for your spouse's divorced your ex spouse or deceased spouse's pension interests. You will not, for example, be able to claim spousal maintenance upon the dissolution of that relationship, whereas when you are married you have certain legal protections. So I think, first of all, people in long-term committed relationships who classify themselves as being life partners need to be aware of steps that they need to take to protect themselves while they are still in that relationship at the inception, not when things are about to break down.
And, Lorette, you mentioned, certainly very important, if somebody passes away without a will, they will look at, there's interstate inheritance, which will look at the spouse and what defines a spouse. But the other one that I've picked up quite often is actually on the tax side as well. So SARS, donations tax, for example, can become an issue if you're not legally married and one partner perhaps puts in a huge amount of money into the other person's bank account, for example. Those sorts of issues can actually trigger donations tax. So it's actually quite, in South Africa, quite a legal quagmire if you're actually not married.